NACDL proudly presents Criminal Justice and the Media, a three-part series exploring how journalists can inform the public on the criminal justice system. Criminal Justice and the Media is generously supported by the Foundation for Criminal Justice and the Park Foundation.
Welcome to the trial segment of Criminal Justice and the Media, a three-part tutorial series exploring how journalists can effectively inform the public on the criminal justice system. This project is supported by the Park Foundation and the Foundation for Criminal Justice. Today's discussion will focus on the topic of covering trials. My name is Susan Walsh, and I'm a partner in the law firm of Vladeck, Waldman, Elias Engelhard in New York City. I've been a member of the National Association of Criminal Defense Lawyers since my law school days here in D.C. at the George Washington University Law School. Having tried cases for close to 20 years, both in court and once in a while in the press, it is my distinct pleasure to bring to you today the distinguished journalist and consummate professional, Linda Deutsch. In more than 4 decades with the Associated Press, Linda Deutsch has established herself as the nation's leading expert in coverage of high-profile trials. She was named Special Correspondent of the AP in 1992 in recognition of her long career as the AP's premier courtroom reporter. This designation has been bestowed on only 18 AP reporters in their history. Linda is the recipient of many other awards, including the University of Missouri's Honor Medal for Distinguished Service in Journalism and the Society of Professional Journalists National First Amendment Award. SPJ also honored her as the Fellow of the Society, the highest honor awarded for contributions to the journalism profession. A tireless champion of the First Amendment to the U.S. Constitution, Linda has been the eyes and ears of the public at trials, including trials of Sirhan Sirhan, Charles Manson, Patty Hearst, Angela Davis, Daniel Ellsberg, John DeLorean, William Kennedy Smith, and the Menendez brothers, and most recently the trial of Michael Jackson's doctor, Conrad Murray, who was convicted of involuntary manslaughter. Linda was a Pulitzer Prize nominee for her coverage of the O.J. Simpson criminal and civil trials. Linda is a native of New Jersey and a graduate of Monmouth University, West Long Branch, New Jersey. And before joining the AP in Los Angeles, she was a reporter for the Perth Amboy New Jersey News, the Asbury Park Press in New Jersey, and the San Bernardino Sun in California. In 2010, she received the American Judicature Society's Tony House Journalism Award, which cited her 45 years of outstanding news reporting that enhances public understanding of the courts and significantly improves the administration of justice. The announcement read, "Deutsch ranks as one of the nation's preeminent chroniclers of the legal system, whose clear, concise reports have connected millions of readers around the world to the inner workings of America's courtrooms." Welcome, Linda Deutsch.
Good to be here, Susan.
Thank you so much. Linda, you literally wrote the manual for the AP on covering trials.
I did.
And so, since many of our viewers will be newer journalists or communications or journalism students, can you tell us perhaps a little bit about how you came to doing the criminal trial beat and what your experience
It was not my original aim in journalism to cover trials. It was something that kind of happened because of history. And history actually has dictated a great deal of my career. I often say that I am a social historian because the trials I covered were so symbolic of what was going on in the popular culture at the time. If you start with my first big trial, which was Manson, it was the trial of the 60s of flower power, hippies, and incredible violence and drugs. And I went on to cover such things as the Angela Davis trial, which took up the Black Panthers and that kind of violence, the Patty Hearst case, which was post-Vietnam alienation by young people, the Ellsberg trial, which was the trial of the Vietnam War while the war was still going on. Those all have been history. I came to California from my native New Jersey with stars in my eyes, planning to be an entertainment reporter. And some people say, well, you did become that, but not quite. I got to California at a very fortuitous time and joined the AP in 1967. In 1968, Robert F. Kennedy was shot in Los Angeles. I covered that, and I was assigned as a backup reporter on the Sirhan trial, another huge historic trial. And then, little more than a year later, in 1969, Sharon Tate and her friends were killed in Los Angeles, and I was assigned to cover that. When the Manson family was arrested, I was assigned to the trial, but I was very young at the time, and so the AP decided to bring someone more experienced in from New York. And he came in and looked at this scene, which included the Manson family camped on the sidewalk outside, people having LSD flashbacks in the courtroom, Manson leaping across the table at the judge. It was that kind of thing, and they were saying it was going to last for a year. And this other reporter said, I think I had a vacation scheduled. And he left, and he never came back. And so for the next year, I, in my early 20s, was covering what would turn out to be one of the most historic criminal cases of all time for the world's largest news agency. It was an incredible opportunity. And at the end of it, I had survived, which was kind of my trial by fire, and I was a trial expert, even though no trial would ever be like Manson.
And starting back in the early days when you did that, and today, if it applies, how do you approach particularly covering a criminal trial? I mean, do you have background in law? Do you need to have a background in law?
I had no background in law. In fact, I always tell the story that on one of my first federal assignments, I was sitting there next to another reporter, and there was a big argument going on, and I turned to her and I said, "Who's mandamus?"
Understood.
And
Did she have the answer?
Yeah. She said, no, it's a writ of mandamus. And so I was starting from ground zero, basically. But I had the good luck to have a great mentor who was a woman named Thea Wilson, who was the trial reporter for the New York Daily News. She had done some of the most famous trials. She did both Sam Shepard cases. She was quite a bit older than I. She became my best friend, and she taught me a lot about what you do as a reporter. Number one being you don't leave the courtroom if you can help it when testimony is going on. During the Manson trial, which she was there for also, reporters would leave the courtroom and go have a smoke. Some of them were out smoking when Charlie Manson jumped across the counsel table at the judge screaming at him, and they missed the whole thing. She also said you can't be swayed by either side, by the prosecution or the defense. There's going to be spin from both sides, no question about it. Everybody wants to get their viewpoint across to you because you have the eyes and ears of the public. And so I learned to listen and to talk to both sides. But in the end, you have to filter out the noise and look at the facts. And the facts come from the witness stand and from the mouth of the witness. And, you have to realize when you go in there that you are in a very privileged position. You are part of the system. I think that's a hard thing for me to often get across to judges. But the press is part of that system. Without us, there would be no public trial in many of these cases. And the message of the justice system would not get out. And that's my mission, is to get that message out and to report fairly and accurately. I never tell the audience what I think is going to be the outcome. That is not my job. Everyone says to me to this day, do you think O.J. did it? Well, I never made up my mind, and it's not my job to decide it. That's the jury's job. Did I think that they proved him guilty? No, they didn't. And because of my attitude toward coverage, some defendants have come to trust me so much that they would talk to me after the trial. O.J. Simpson was one. He called me right afterwards, after he got out of jail, to thank me for having been fair to him. And he would say later in an interview, he said, you know, she never said she thought I didn't do it, but she never said she thought I did it either. And that's why I talked to her. And a very similar thing happened with Michael Jackson after he was acquitted. He went off to the Middle East somewhere, and oddly enough, I got a call from the prince who was his host in Bahrain saying, Michael Jackson would like to talk to you. And he called also to say he thought I had been so fair to him, and he wanted to thank me. I think it's kind of sad that reporters in this day and age have to be thanked for being fair. That is our job. And if you come into a trial realizing that the defendant is in the worst possible position he or she has ever been in their lives, and that their lives often are at stake, it is your obligation to tell both sides and to give everybody a fair shot.
And is it frustrating for you as covering a trial that I imagine you don't have a whole lot of access during the course of the trial to somebody that's on trial? And is it frustrating and how do you get the story across without that access? You said that people call you afterwards,
Right.
But during the course of the trial.
Obviously, if they're in jail, they can't talk to me. If they're not in jail, yeah, they talk to me while they're outside. I mean, during O.J. Simpson's last trial in Vegas, he was in the hallway talking to me all the time. It's not essential to talk to the defendant. There are a lot of other people to talk to. And as I said, most of what you're reporting is going to come off the witness stand. It's a great temptation to quote lawyers incessantly outside. In the O.J. Simpson trial, they held press conferences. Perhaps the most famous was the DeLorean trial, in which Howard Weitzman, the lawyer, held a press conference on the courthouse steps every day to basically propound his client's innocence. You can report on that, but you have to get the other side. You have to go back to the prosecutor and ask the prosecutor, what did you think of what he said? It's a balancing act, very much so. I have a lot of friends in the defense bar. I have friends who are prosecutors. All of them talk to me because they know that I will give both sides of the story. And my theory is that your readers or your viewers, depending on which media you are in, are smart enough to make their own decision. At the end of the DeLorean trial, I had been so scrupulous in that case about not taking the spin and making it fact and reporting both sides. And at the end, one of my desk editors was talking to me after the acquittal, and he said to me, you know, anyone who read your stories every day would have known this was going to happen. And I thought that was amazing because I didn't know it was going to happen. Mm-hmm. But I did give both sides, and that's how it came out.
And in the section of the manual that you wrote, you cite to a lot of other sources that you use besides the lawyers. For example, you encourage some journalists to contact the judge or the judge's staff. How does that work, and how do you get access to people besides the parties' representatives that are engaged in the trial itself?
It's very difficult to get judges to talk to you. I've been around long enough that judges do talk to me because they've gotten to know me. But the judge's staff is crucial. You have to know the court clerk. You have to, in many cases, it helps to know the court reporter who's taking transcripts because you may need to order one very quickly if there's a question about something that was said. And right now, some of the court reporters will email me their transcripts if I pay for it. And that's great because it comes very quickly. Or if I have notes and I'm not sure whether I was right, I may run up to them and say, was this correct? The clerk is essential for getting documents, for finding out schedules. The clerk is the voice of the judge, and the bailiffs. The bailiffs are important too because they let us in the courtroom, they give us our seats. In a very high-profile trial, I will almost always ask for a meeting with the judge in advance because there's so many things that have to be arranged logistically. Whether it's, who gets to be in the courtroom. Normally the press has a committee, and we set up the seating and decide which of our numbers should have seats fairly allotted in the courtroom. In the Michael Jackson case, which was probably the most heavily covered of any trial I have ever done, we had months of meetings of our committee to arrange the logistics and to arrange to get documents. In some trials, we will, in the days before big computer delivery, we would get Xerox machines in the press room so that we could quickly copy documents for everybody. Documents are essential. You have to be able to read what's been filed. And now it's very valuable if you can get a lawyer to send them to you by email, and many of them will.
And besides reading the documents that are filed, are there other materials that you use? And for example, there's many instances in a trial that the jury doesn't get to hear certain parts of the evidence. Are there documents that they're precluded from seeing, that they're not allowed to see in coming to their verdict? Do you get access to those? And how do you make a decision as to whether or not you should or report on those because the jury doesn't get to see them? And how do you balance that, or how do you make a decision about that?
I think that, my view, being a very ardent First Amendment advocate, is that everything is open and that we should be able to see everything. One of the big battles we had for a while was getting access to jury questionnaires, and we're still fighting it, believe it or not. A recent trial I did, the judge refused to release the jurors' answers. It's essential to see those answers if you are going to know who the jury really is, who the members are, what their views are. In many cases, they will disclose something in the jury questionnaires, the written questionnaires, that they will not say in open court. And you have to be very alert to know that you should make a request in advance. I remember going into another district where I was covering a trial and said to the local reporter, "Do we have the questionnaires?" And he said, "What questionnaires? Are we supposed to ask for those?" "Yes, you are." And technically, according to the law in California at least, you do have access to them. It depends state by state. That's a big one, jury questionnaires. The identities of the jurors. In California, we now have a rule that doesn't allow them to be named, which I think should be fought, because unless it's a gang trial or a mob trial or something where a juror's identity might endanger them, I think the names should be public.
Which leads me to a question about your coverage of a trial of a juvenile. You recently were in a pool of reporters that covered, I think it was a 12-year-old that was accused of killing his father. And you repeatedly in all of your reporting refused to disclose his name. How do you distinguish what you just said about juries knowing their name with your decision not to publish the name of a juvenile on trial?
That is a policy that is observed by the Associated Press and by many newspapers. Most newspapers do not name juveniles. He was so young. It was odd because his father's name was disclosed, and so anyone who knew the family would clearly know who he was, but other people wouldn't. It's an area that's open to discussion, just as we do with rape victims. That's even more controversial, because we don't name rape victims unless they want to be named. and how many people can go to them and ask them if they want to be named. There have been some very brave women who have come forward in the media and said, I was the person in the trial, and I don't mind if my name is used. It helps because in many cases editors will not publish verbatim quotes from someone whose name is not associated with the quote. We can't say a source said and then put it in quotes.
And how has the coverage of criminal trials changed from when you began to today? You mentioned, for example, it's changed. Of course, it's changed for trial lawyers because we also get the email of the transcript immediately, as opposed to waiting for it or running down to the courthouse to get it to prepare that night. But how do you compete with media today that is 24/7, either gavel-to-gavel television coverage or internet or other sort? And is there a place still for the print journalists to compete in covering trials?
Well, you said the print journalist. The print journalist now is often online. My copy goes out everywhere. I often tell the story, which I find very reassuring, during the Michael Jackson case, the molestation case in Santa Maria. The press would line up every day and be herded into the courtroom. And the fans of Michael would be behind a chain-link fence. And they would stand there and they would chant, "The press are liars, the press are liars." And I would just kind of wave at them happily and go in. One day I was coming out into the courthouse early. I arrived early, and 3 young women were there making their placards to put up. And they came running up to me and said, "Miss Deutsch, we need to talk to you." And I thought, oh dear. And they came up and they said, "When we say the press are liars, we don't mean you. We read you on the internet every day, and we know that you're fair." So there are many ways that people have access to print now. Almost every newspaper has an online presence. And so you're writing for a larger audience than you did in the past. When I covered trials early on, there were no cameras in court at all. I always said, had the Manson trial been televised, the whole country would have stopped, because every witness, if you watched the O.J. trial, every witness was Cato Kalin. It was so sensational and so riveting and such an opportunity to see inside a subculture. But there were no TV cameras in court then. Even at the O.J. trial, and that was the most heavily covered up until then, it was gavel to gavel on a couple of channels. CNN had gavel to gavel. But there were no 24-hour tabloid TV shows. They just didn't exist at the time. Sorry. So that is a huge difference. Now everything is instant. You know, the instant report on television is a big thing. My colleagues in TV have to run out and file instantly. It's kind of what I did back then, because the wires, I always say the AP was the original internet, because the wires went out to everybody in the media. And so I would have to race out of the courtroom, dictate a quick breaking thing, and dictate the whole story. And that would be the first word of what had happened. Now you're more likely to get the first word on TV or radio.
And do you approach your coverage today differently than you did early on? Now that there is cameras in some courtrooms, and there are these half-hour shows that cover trials, either celebrity trials or making the trial a celebrity by the coverage of it.
I think the biggest difference right now is in length of stories. The AP does not want long, involved stories, nor does any newspaper, mainly because of the shrinking news hole, which means that there isn't enough advertising to support long stories. And so where I would, in the Michael Jackson trial, it was let it go, just write as much as you can. Everybody wanted to know everything. You can't do that anymore. I have to condense. And even though the real credo of journalism is to condense, is to tell it short, tell it accurately, but don't go on and on, now it's extreme. Some people have said that the internet doesn't want stories over 300 words. In a case of great magnitude, that's very limiting, and it's almost like being in a straitjacket.
And I want to talk to you a little specifically about the law part of the trials that you cover. And you cover them in 50 states, for example, and federal trials, all that have different legal systems, different rules of evidence, different. How do you familiarize yourself with the jurisdiction? The Exxon Valdez was in Alaska,
Right.
which is different than California law, for example. And the Ellsberg trial was tried in a federal courtroom. So
Right.
how do you tackle
Well, you do a
that?
lot of reading, but you also do a lot of talking and interviewing, because the Exxon Valdez trial is a perfect example, because I was sent there at the last minute. We just didn't have enough people in Alaska. I think we had 2 people in our bureau then to cover a huge trial like this. And so I was dispatched, and my bureau chief, when he got the request, said, well, yeah, she can come, but she lives in California. She doesn't have the clothes. And so I got a parka and thermal underwear, and I went. But I got there, and I suddenly realized from the first day that the issues in this case centered on maritime law. I had never even heard of maritime law, nor did I know there was such a field. And so I was flummoxed. And the first day I went up to the defense lawyer, and I said to him, his name was Michael Chalos, I still remember him. I said, Mr. Chalos, I am lost here. I don't know anything about maritime law. And he said, that is my whole practice. Come back to the hotel, we'll get together in the coffee shop, I will sit you down and I will tell you everything you need to know. And he did. And it was just so valuable. And I finally understood. I talked to more people about maritime law. And I always said that by the end of that trial, if I had to steer that tanker, I could have.
And besides just learning the law, there's also extremely technical issues that are tried in these cases. Mm-hmm. The Exxon Valdez case, not just the maritime law, but how to steer the tanker.
Right, and shipping lanes. You had to understand how shipping lanes worked, why this ship went aground. It was...
And in the other cases, there's forensics, for example,
Mm-hmm.
and you have to educate yourself on that.
Right.
And do you also do that the same technique, generally by talking to experts in the
Well,
field?
I was there at the infancy of DNA,
Mm-hmm.
and that was very difficult to understand. It was the OJ trial. It was the first place it really became hugely public. And we had to listen to weeks of explanations of alleles. I still remember the alleles. And I'm not sure I ever totally understood it, but you didn't have to. All you had to do was understand enough to tell the public that what the odds were that this was his blood. And the odds would become pretty evident. The detailed testimony was for the benefit of the jury. So if they wanted to know more about how DNA worked, they got it. There are a lot of technical issues in trials, and I think one temptation to reporters is to report all of this, and you don't need to. To get bogged down in details of forensics, for instance, is not going to benefit your audience, because they probably won't have the background knowledge to grasp it. And they also are not interested. It's like my friend Theo used to say to me, nobody wants to know how you got the story, they just want the story. And so that's kind of a guiding principle. Reporters are tempted to say, oh, well, I had to read 50 books to learn about this. Nobody wants to know that. There is now so much material on the internet that your research possibilities are endless. And so I do try to read up, if a defendant has an interesting background, such as John DeLorean, who was a titan of the automobile industry, you read everything that there is available about him so that you really know what this man was about. The same thing could be said of Phil Spector. I was at an advantage because I was a big rock and roll fan, and actually Phil and I had long conversations about that because we were both Elvis fans. And so I knew his background instantly when he was arrested. I knew who he was, and I knew the importance of his legacy in the music business, which, although it was not part of the case, was the background. You had to mention who he was. And a lot of the people I cover do wind up being famous people in their own right, not just because they're charged. O.J. Simpson was the most famous American ever charged with murder. That's huge. And so even though I was not a football fan, I had to research his football career, his movie career, all of it. And it always helps in doing the story if you do research.
You did that kind of reporting and research not only on the defendants and the celebrity defendant or otherwise, but also sometimes you report on the lawyers. And sometimes there are lawyers or other parties or expert witnesses that become celebrities or want to become celebrities as a result of a trial. Some of your reporting includes backgrounds not only just on the defendant but also on the personalities in the trial. The Judge Ito you wrote about as well. And I think in the Hazelwood trial, his lawyer actually was a colleague of his at Maritime Academy.
They went to school together.
Yeah, and that's how he chose him as his lawyer eventually. And you wrote about that.
Right.
So, and is that part of the trial coverage? And do you think that's important for a journalist to include?
Oh, I think it's important to include anything that reflects on the humanity of the people involved. The trial is such a human story. And if, you consider the search for justice really based on the search for knowledge of the human condition. That's what it's about. And so, I have seen some defendants who are so evil that you may not want to look into their backgrounds, but if you do, you may find some explanation of why they did what they did. That's in the most terrible of murder cases. In other cases, you can find out an awful lot by talking to lawyers. I usually try to do profiles. If there is a famous lawyer involved, or someone who's actually well known even in their community, I will do a profile of the lawyer in advance. It's a way to get to know the lawyer because you go and interview them, and it's a way to let the public know who it is they're going to be watching. I mean, you couldn't do the O.J. Simpson trial and not write about Johnny Cochran. And I had known him for many years, and so it was very easy to write a profile of him. One story I always tell about the value of talking to lawyers was in the DeLorean case, because I had known Howard Weitzman for a long time. But I decided he's going to be the voice of DeLorean. DeLorean was a huge figure. And I asked him if I could come to his office and interview him for a profile, and he said sure. At that point, no one had talked to DeLorean. He was being held quietly.
Yeah, and remind me, this was the sting operation being placed on trial.
John DeLorean had started he had been the brains of General Motors. He retired and he started a company in Ireland to build the DeLorean car, which actually became the Back to the Future car in the movies. Mm-hmm. It's quite an extraordinary car. It's the one with the doors that go up.
Right.
And it's stainless steel. And he was very famous, and he had gone to Ireland because he could raise money there. He was running out of money. And so the government had this idea to set him up for a sting operation in which they would offer him a chance to sell cocaine and make the money for his car company. It was a very ill-advised plan. They used a rather shady guy to do the proposal. When DeLorean said no, they went back to him several times, which is you're not supposed to do in a sting operation, and pushed until he said he would do it. It wound up being a classic defense triumph, because you had a defendant who was videotaped looking at a suitcase filled with cocaine and saying, "That's better than gold," on videotape. And he was acquitted because the defense was able to show that he was set up and it was entrapment. And so he walked away with, no penalty, although his career was ruined, as often happens with famous defendants who are acquitted. But on that day, when I first went to interview Howard Weitzman, I walked into his office, and who was sitting there? DeLorean. And he let me interview him that day, which was a huge scoop. But that was partially because Weitzman knew me and knew I would, follow rules. I wouldn't try to do any kind of an attack interview. But it showed the value of trying to do it. I did do the profile of Weitzman as well. And some of the profiles wind up being useful in future trials, because a lot of these lawyers come back again and again. And people who want to look them up will find your story and look at what their background was.
And how do you start building that kind of trust and relationship? I mean, you obviously have access because of your extraordinary reputation as being fair-minded. But for somebody that's not known to the public and doesn't have the reputation established already, how do they go about building their credibility so that they can have access to cover a trial for the public in a fair-minded way?
Well, I think that in a way, the reporter who's covering on a local basis has a better opportunity than someone who's trying to get into the national field, mainly because it's your courthouse in your town, and you can get to know the court clerks and the people that run the courthouse. You can get to know the judges. You can get to know all the lawyers who practice there. I have a colleague in Las Vegas who covers the courts there all the time. Everybody knows him. The court administrators, the lawyers, the judges, everybody knows him. And so if something is breaking, they'll give him a call. That's very important. And I don't think they would think of having a trial and trying to bar him from the courtroom, which is another area where you have to be ready to fight, because some judges don't want coverage in their courtrooms, and I've had to go to get my own lawyer to get access. Access is a huge issue. But if you are the beat reporter in a town, you can become known fairly quickly. And if you do a fair job and they see your stories and they say, "Wow, she does a great job," they're going to remember you.
When you say access is so important and that's a battle that you've fought, can you elaborate a little bit on that?
I think that a lot of judges, they go to school and they learn everything, but unless it's their field, they don't learn First Amendment law. And there are a lot of precedental cases which you have to become familiar with, because I can cite them in court. And when a judge says, "I'm closing the courtroom," or "I'm going in chambers for this hearing," you have to object. And it's a constant battle, because I always tell young reporters, you are not an invited guest in the courtroom. A lot of people would prefer you not be there, including the defendants and the prosecutors. They would rather hold this little thing in private. And that's not what the law says. It's not what history says. This is a public proceeding. And without reporters there, often it is not public because the average person out on the street does not have the time to come to court every day and spend their whole day sitting there witnessing it. And so when a big trial is held, often they say, well, we have to have seats in the courtroom for the public, and so maybe we'll keep the reporters out. No. To let me in, you are letting in thousands upon thousands of people. To let a member of the public in, yes, there have to be a few, but they're going to tell their neighbors or their husband or wife. They're not going to tell the whole world. And so you do have a privileged place in this courtroom. And you're part of it. My license plate on my car is Fourth Estate. And you are the fourth estate of the government, of the judicial system, according to British law. And once you understand that, and you understand that you have a right to be there, and you know the law, I think that you know how to argue. It helps if you work for an organization that has lawyers and can call on them to defend your right to be there.
Can you talk about that a little bit and the role of the press and the First Amendment in the context of your coverage of the Daniel Ellsberg trial? And of course, he was tried, prosecuted for
espionage
and publishing the Pentagon Papers,
Mm-hmm.
and what role the press played in that particular historical event. And maybe talk about that a little bit in the context of what we're seeing today.
Sure.
With WikiLeaks and the Snowden.
Mm-hmm.
Can you explain that a little bit?
Well, the press was in a very difficult position in the Pentagon Papers trial. Now, there were two trials. There was the trial over the papers, which was in New York, and then in Los Angeles there was the trial of Ellsberg and his colleague Tony Russo, who had released the papers. This was a 47-volume study of the Vietnam War, and it revealed a lot of things that everybody in government knew, but the public didn't. And it was historic, it was monumental. It brought into conflict the military and the government and the public, the public's right to know what was going on. A lot of things about classified information, what was classified, what was not. The press was in a very difficult position because we had collaborated, so to speak, with Ellsberg in releasing the Pentagon Papers. The New York Times and the Washington Post could have been unnamed co-defendants, but they were not. And we were in a position where we knew, among other things, that we were being followed and we were being taped by the FBI. Ellsberg was too. I mean, a lot of things came out afterwards, and everybody was being surveilled during that trial. There was no trial in the end. There was a pre-trial, and there was a lot of testimony. The trial began, but it never ended. Because it came out during the trial that the Watergate burglars had broken into Ellsberg's psychiatrist's office in Beverly Hills and stolen his records. And that was kind of the final nail in the coffin of that trial. There had been other violations as well. The judge during the trial had gone and met with Ehrlichman and Haldeman, Nixon's aides, and had been offered the job of FBI director during the trial. He also met with Nixon himself at San Clemente. And so it was obvious the judge had committed misconduct, and the break-in was clear misconduct. And during the case, so much happened. The judge in Washington, Sirica, released the transcripts of the Watergate investigation, which had not been released. And that was how we found out about the break-in. In the end, the case was dismissed for outrageous governmental misconduct. And so a trial that had so much attention and had so many amazing witnesses. I mean, Jane Fonda testified, Tom Hayden testified, the Alexander Haig testified. It was huge. It never concluded. It was a dismissal. And Ellsberg was kind of disappointed, even though if it had concluded, he could conceivably have gone to prison for life for espionage. But I've talked to him many times since then. It was a hard story to write because clearly we had a position. There was no question. I mean, we were the unindicted co-conspirators. And we had to be fair no matter what. And that was truly a balancing act, to just write everything as it happened. And I think I did that. But Ellsberg has said to me that two things. One is, if this had happened now, he would never have had to Xerox 47 volumes of a study. He said he would have put it right out on the internet. And the other thing, and he would not have gone to the newspapers, which would have been a mistake, because the newspapers were able to vet the material and to choose what was important. You couldn't have put all 47 volumes out. And the other thing he said was he felt that Snowden did the right thing by leaving the country, because he feels that if Snowden had stayed here, he not only would have been prosecuted but convicted of espionage and could have faced the death penalty.
And how would you say that your experience, I mean, it's daunting, the might of the federal government, regardless, but the FBI following you and surveilling you. How would your experience today inform journalists trying to cover the Snowden case, if there is a prosecution brought, or some of the WikiLeaks cases, or those type of NSA cases that are probably coming down the road?
Well, I think the only advice is to be careful, because you probably will be under surveillance. And there have been a great deal of conflict between the government and the press recently. The AP was at the center of one where our phones were being tapped. Everybody at the AP pretty much in New York and Washington had their phones tapped, which was outrageous. But you know, you have to realize that your stories are being scrutinized. If you're covering something of that magnitude, your stories are being scrutinized everywhere, and at the highest levels of government. And they, you know, people are going to try to get you to alter your views. They may try to stop your coverage. It's a constant battle.
Just want to switch gears a little bit to the role of a journalist in informing the public, not just of what's happening in the criminal trial, but of the integration of what's happening in the trial with the law. There was a time in the O.J. Simpson trial where Nicole Brown Simpson's sister said in the pretrial stages to the media, if he's so innocent, why are they moving to suppress all of this evidence? And there was a lot of pretrial litigation about keeping some of the evidence that was collected from his Brentwood estate and stuff out. You dedicated an entire article to that and follow-up on the Fourth Amendment. And why did you do that, and how did you do that?
Well, I think the idea was to have the public understand why lawyers make motions under the law. The Fourth Amendment is not that well understood by the public. The First Amendment is pretty well understood. And, you know, you have to say, this is not because they're trying to fool you or, you know, put something under the rug. It's that a defendant has the right to the best defense. And a lawyer has to use every legal tool at their disposal. And it's a very tough thing to sell, not particularly in that case, because that case was an anomaly. It was different than any other case. But let's say we have a mass murderer, and the lawyers are making efforts to suppress evidence. People will say, "Oh, that's terrible," but the reporter who covers courts all the time will understand that the defense attorney's highest calling is to give a defense to the indefensible, the person who you don't think you could ever defend. And it's what sometimes drives lawyers to drink. It's very difficult. You know, how do you defend someone like Timothy McVeigh? I didn't cover that one, but that had to be the toughest. There are a lot of these cases. How do you defend a terrorist? You do it according to the law, and you use every tool at your advantage. It's something that the public should be educated in, so that they don't immediately condemn a lawyer for representing the indefensible, seemingly indefensible.
And which leads me to the question is, what do you do as a journalist with the criminal defense lawyer that says no comment or I can't speak to the press, particularly in the context of trial, when they're in the middle of a trial? And it may not be because they have nothing to say or have something to hide. It may be because they have a whole lot to do that evening to prepare for the next day. But how do you deal with that as a journalist when the criminal defense lawyer says no comment?
I tell them this is of no value to me. If you want to serve your defendant well, you will comment. You will say something. I often give speeches to groups, criminal defense bar, and at the end of my speech is always, please don't ever say those horrible words, no comment. They are, they have too many implications. Usually the implication is, I can't say anything because my defendant's guilty. People will think that. A no comment has many levels of interpretation, and it's not a good idea for them to do it. Personal relationships can help if you can talk them into this and say, just talk to them and say, that's not helping anything. Can you just say some very small comments so we have something from you? One of the problems is that when a case begins, the prosecution has the podium. They have the charges that they file. They have motions that are filed immediately. They tend to have the advantage because they have the public attention. We have arrested this monster, that kind of thing. And so for a defense attorney at that point, they start behind the 8 ball here. They have to quickly make up time, and unfortunately, that is about the time that the prosecution will move for a gag order. And then the defense attorney can't say anything. We have argued from the press standpoint against gag orders. We've gone up on appeal with it. Because it is unfair to everyone to gag a lawyer at a point when the other side has already publicly convicted their client. All of these areas have to be litigated. And that's the problem, which is that many news organizations do not have the funds to litigate. So you look at case law and you try to find something that supports your position. And hopefully a good First Amendment lawyer can argue it briefly and without too much cost.
And so when that situation arises, when the prosecution or the police have the podium first, which is ordinarily the case, to what extent do you as a journalist rely on their version or on their presentation to present the case to the public at large in your column or in your article?
Well, you have to report what they say. One of my first questions will be, who's representing the defendant? and then call them. Or call an expert, a legal expert, and say, if you had this case, what would the answer be to this? You can't just present the prosecution version. Although in the first hours when the story is breaking, you do, because that's all you have. You have, an indictment, you have a criminal complaint, whichever it is, and you report what's in it. And then you go to whoever can answer or whoever can give you an educated assessment of this.
So you want access to both sides regardless, I'm hearing you loud
Absolutely.
and clear.
Absolutely.
And not always as more easily said than done, I understand too. Do you think that the public understands what's happening in the courtroom? Or do you think that the public perception of our criminal justice system is, the word is getting out there as to how it functions? And
I think that, oddly enough, the O.J. Simpson case, which was so heavily criticized, I think that Judge Ito did a great service to America, because it was like a civics lesson in how a trial works. And many people said to me, oh, it's so tedious, it's so boring. There are times when it's boring. The public had to listen to hours of DNA testimony. But he offered at least an insight into what goes on in court. One of my favorite cartoons that came out of that case was in the New Yorker, and it showed a boy and his father at the dinner table. And he says to him, "Dad, I'd like a sidebar." And so people got familiar with the language. It was not your average trial, obviously. It was quite different. But they saw how defendants were in the courtroom, how witnesses testified, how lawyers argued, how evidence was challenged. I think it was a huge educational function.
And as somebody that was there every single day for that trial, what is your takeaway from it in terms of educate the system as a whole that you've seen? I mean, you've also covered people that are not celebrities and that are not gavel to gavel coverage like that quote unquote trial of the century of the moment. So what is your takeaway from that whole trial experience?
From the O.J. trial?
Yeah.
It's not like that in most trials, but then most trials are not like Manson either.
Mm-hmm.
When I covered Manson, I thought, oh, that's how it is. Oh, this is exciting. People jumping up and down, screaming and singing in court. And no, it's not like that. And it's not like the O.J. trial either, because the stakes were so high and the interest was so vast. But if anything, the Michael Jackson trial was even bigger, and he was acquitted. And that's the challenge for a defense attorney. How do you get someone acquitted in a case that has such vast attention? And if they are acquitted, is that the end of it? Usually it's not. I have talked a lot about defendants who are acquitted and whose lives are ruined by the experience. O.J.'s life was never the same, and obviously he's now in jail. Robert Blake, who was acquitted of killing his wife, just is kind of a lost soul now. He had the misfortune to be charged. John DeLorean was acquitted, but he never came back, really. The experience of a high-profile trial for a defendant is often devastating. And we have to realize our responsibility in covering those cases, because we shine the light of publicity on them. And that's why I think it's so important to be fair, because the public is going to see them forevermore as they were in that case. And sadly enough, it will probably, for the famous ones, it will be the beginning of their obituaries. Not everything they accomplished in their lives, but the one instance where they did something bad, were charged or didn't, and were accused of something bad. And the trial that happened, and yes, they were acquitted, but I mean, how many people believe that O.J. Simpson was guilty even though he was acquitted? It's very tough for a defendant or a former defendant.
And do you think that's part of the coverage of the criminal trial as a journalist, the responsibility to follow up, to see what happens?
Absolutely. Absolutely. Some defendants would like to fade into the woodwork and not be heard of again, but unless they are not famous, it's not going to happen. People who were famous and stand trial and walk away are just walking into another spotlight in a way, and they will always be famous for that.
There was a very complicated psychiatric or psychological defense in a trial that you covered in California about 20 years ago, the Menendez brothers trial. And that had, like I said, very complex psych defense. How did you cover that? Because that is not only difficult to present in a courtroom to the jury, but to relay to the public at large in an article. So how did you go about doing that? Can you talk a little bit about it?
It was an incredible trial. I've always, I have this theory about social significance, and that was the first trial that I can remember that revealed this dirty little secret of child sexual abuse in families and in rich families. This was a very rich family. And no one had kind of talked about that ever before. And they claimed that the boys, the brothers, were sexually abused by their father and thus killed their parents. It was a very unique defense. It had not been offered before. Leslie Abramson brought in experts to talk about it.
She was the defense lawyer.
She was the defense lawyer. I did a lot of research because the subject had been written about in scholarly journals. And I talked to psychiatrists about it. It was the days that the boys testified, which they did, were heartrending. They were very, very affecting witnesses. Some people did not believe them, but the first trial ended in a hung jury. The second trial ended in a guilty verdict. It was very difficult, even with that defense, to justify the killing of the mother. They killed both parents. And actually, one of the things I remember so vividly is that after that trial was over and they were sentenced to life without parole, I was able to speak on the phone with Eric Menendez before he went up. And I said to him, "Do you have any regrets?" And he said, "Yes. I wish I had not killed my parents and I had killed myself." It was a very sad trial.
And during the course of those two trials, did you have access to the defendants as
No.
well? You started out talking a little bit about this, and you just touched on it again, is that you see the trials that you've covered over the course of your career as a reflection or a commentary on societal movements or what's happening. Can you elaborate on that in the context of some of the other trials that you've covered? And you mentioned the Manson trial,
Right.
and of course this Menendez trial now, and what about some of the other ones?
Well, a huge number of them have that implication. Charlie Manson really was the first cult leader that we ever covered, and there were a lot of them after that. The Unabomber trial, which actually never got past jury selection, was a reflection on terrorism. He was maybe our first big terrorist who held the whole country hostage with his manifesto and his bombings, in which he killed and maimed a lot of people. And that was a case that focused on that area. The Michael Jackson case, oddly enough, was also significant in that it focused on celebrity and the price of celebrity in our time. Michael Jackson was not guilty of molesting any child in that case in the trial, and he was found not guilty. But because of his celebrity, he never escaped the stigma. And it was, it was a look at what happens when you try the most famous person in the universe, which is really what he was at that point, next to the president, I guess. He was the most famous. And whether you could get a fair trial. And he did. He had an incredible lawyer, Tom Mesereau, and he got a fair trial, but he was such a target. And that came out at the trial. On the day of the acquittal, I was at the press conference with the prosecutor, and I said to him, "Are you through chasing Michael Jackson now?" And he said, "No comment." And that night, Michael Jackson left his beloved Neverland estate and left the country. Never, didn't come back for years. That was socially significant. The Patty Hearst case was socially significant. It was the conflict between parents and children. She declared her parents to be ageist pigs when she was kidnapped by the SLA. It was the SLA people, some of them had been in Vietnam. It was post-Vietnam alienation. It was the issue of the homeless came up because the SLA demanded that her father feed the homeless on the streets of San Francisco as part of her ransom, and he did. There were so many issues. In the DeLorean case, I saw that as the ultimate case of the 80s because it was a glamorous figure, once very wealthy, inventing a super fast car. He had a gorgeous wife, and he was trafficking in the drug of choice at the time, cocaine. What could be more 80s? The Exxon Valdez trial, 1990, first trial of the 90s, and it was a first trial in which the victim was the environment. The oil spill on Prince William Sound in Alaska was devastating to the environment. So, a lot of them have these overriding issues. I covered a trial involving AIDS, the trial of Rock Hudson's lover, who sued his estate. They're not all criminal trials, but this was a suit against the estate for his being exposed to AIDS, even though he never got it. There are, just so many issues that affect the people who are watching these trials and change their lives.
And how does a new, ambitious, budding professional journalist that wants to do it right distinguish himself in covering a trial, like these that you just mentioned, from his peers or her peers, and get a foot in the door?
Do it better than anybody else. What can I say? There are a lot of issues. If you can identify the issues, it helps. For instance, I covered a trial back in it must have been the 70s or 80s, which coined the word palimony. It was the trial of Michelle Triola Marvin versus Lee Marvin, the actor. And she had been his companion and lover for, 20 years, and claimed that he agreed to support her for life. And that became known as palimony. People who were not yet married but were held to pay like alimony. Mm-hmm. And it was a kind of a split outcome, but it changed the law. And that was monumental. And some cases will do that. They will change the law. And that's almost as important as the acquittal or conviction of a defendant, is when you change the law. And these days, palimony is seen as routine, and people have prenuptial agreements, and not that many famous people are getting married anymore. They live together and they have to have an agreement for support.
And so, is there anything that I haven't covered that you would like to, in closing, impart words of wisdom on journalists in particular, that and their responsibilities and their role that I've failed to ask you about?
I think you've been pretty thorough, but I would say that you have to keep in mind that you are the eyes and ears of the public, that you represent the public in the courtroom. Nobody else. You're not on either side. And sometimes I think that in the courtroom I am the only person, or we are the only people, who do not have a vested interest. The jurors, it will be the most important thing they do in their lives, possibly. The only time that someone will ask them to make a decision that affects someone's life. The lawyers' careers may be made or broken in that courtroom. The judge may go up to become an appellate justice as a result of that. But the reporters, we are just the flies on the wall. We are the ones watching, and we are the messengers. We take the message out to the public, and we let them see what happens. And that is our role. We have to fight all the time to be in there and to impress upon the judiciary that our role is important and that we should be given access. I had a case just this week in which there was a verdict, and at the end I wanted to talk to the jurors. That's something we like to do. Mm-hmm. And the judge discouraged them from talking to us. She told them that if they talked to us, they would be surrounded by the press like swarms of locusts. I protested that. I wrote her a letter, and she apologized for the use of the terminology and said she understood. Whether she did or not, I don't know. But we have to fight at all times for access to the jury because they are the ones that make the decision. They are our representatives in the courtroom, the public's representatives. We cannot talk to them during a trial. That's forbidden, and you can't break that. But once it's over, I frequently will ask to have the judge allow us to talk to them in the courtroom before they leave, because they often will say things that didn't occur to us that influence their decisions. Mm-hmm. And it's important to know how the jury process works. We have a very responsible and important position in the courtroom, and I think that as long as we are aware of that and do not allow it to be taken away from us, then the system will survive and will continue to be a benefit to everyone.
Well, thank you so much, Linda Deutsch, for not just for your time today, but also for your incredible body of work that's ever expanding and growing, and the service that you do. Thank you. It's my absolute pleasure.
Thank you.
Thank you.